Types of term. In this podcast, I will introduce you to the different types of term which can exist in a contract. I will talk first about express and implied terms, and then about different types of terms themselves. An express term is one which is specifically agreed between the parties, whereas an implied term is one which, whilst not being expressly agreed, is nevertheless part of their agreement. Where the parties have bothered to document their agreement in writing, the presumption is that the contractual document accurately reflects the parties' intentions. Because of this, there is a general presumption, known as the parallel evidence rule, that prohibits the use of extrinsic evidence, such as evidence of the negotiations of the parties, to add or vary the terms of the contract as they are documented. Although commonly described as a rule, it is perhaps better thought of as a presumption, since the courts seem willing to admit extrinsic evidence in a fair number of situations. By way of contrast, an implied term is one which does not appear in the documented agreement between the parties, but which, nevertheless, forms part of their agreement. Terms can be implied on a number of bases: custom, by the courts, or through statute. I'll talk through each of those. In terms of custom, unless expressly excluded, the case there, Afroter Raini and Leopold Walford, a customary behaviour may be implied as a term of contract. Take a look at the case of Hutton and Warren. Courts may also imply terms into a contract, either being terms of fact or terms of law. There have been a number of tests over the years as to when a court should imply a term into a contract as a matter of fact, including the test of business efficacy arising from the Moorcock case, and the test of the officious bystander from Sherlaw and Southern Foundries. The idea being that this person interjected into contract negotiations with a suggestion for the term that's to be implied would have been rebuffed by the parties saying, "Oh, of course that's a term of the contract." A relatively recent case, that of Attorney General of Belize and Belize Telecom, has been seen to refine the test into a single statement. Is that what the instrument, read as a whole against the relevant background, would reasonably be understood to mean? It seems to remain good law that, notwithstanding this single test set out by the Privy Council, the term must be necessary, not simply reasonable, to imply it into the contract. This remains a high threshold. See the Reborn case. The courts may imply a term of law based on the nature of the contract between the parties, effectively representing a term which is a legal incident of the relationship. Look at the decision of the court in the Liverpool and Irwin case dealing with a council's duty to repair. The third basis on which a term might be implied into a contract is through statute, and a number of laws imply terms into contracts irrespective of what the parties might say. A particularly common situation for this is in the field of consumer protection, in which, for example, the Sale of Goods Act 1979 implies terms as to title and quality of goods into a contract. I'm not going to discuss here what the particular implied terms are. I will make a separate podcast on consumer protection and contracts. But at this point, you may still want to take a look at the Sale of Goods Act of 1979 and Section 14 in particular as an example of a statute implying a term into a contract. So moving on from express and implied terms, I'll now talk about types of terms in a contract. And three types of terms can be categorised: warranties, conditions, and innominate terms. Somewhat confusingly, the words condition and warranty have both specific meaning when they're used to describe types of terms, but also different meanings within the context of contract law more generally. Thus, condition may also be used to describe something which needs to be satisfied before a contract is formed, and a warranty is a form of binding promise. In the context of descriptions of terms, though, they have more specific meanings, and it's those that we'll focus on here. In trying to determine whether a term is a condition or a warranty, a court will be looking at the intention of the parties at the time of contracting. See the Mihalis Angelos case. The first type of term we'll look at is that of a condition. And a condition is a fundamental term of a contract. It goes right to the root of the contract. So fundamental is a condition that a breach entitles the innocent party to both claim damages and also to exercise, if it wishes, a right to terminate. And this right to terminate exists even where the breach is slight. See the Arcos case. As the courts do not seem minded to necessarily take into account how the parties describe a clause, if you want to maximise your chances that a court will treat your term as a condition, as well as labelling it a condition, you could try making it clear that you consider the term to be of fundamental importance, and that any breach, no matter how slight, will entitle the other party to terminate the contract. Note that termination for breach of a condition is different to rescission from misrepresentation. Termination for breach does not set aside the contract as if it never happens, but rather terminates it from that point onwards. The second type of term, a warranty, is a less important term, and breach of a warranty does not give right to terminate, but only a right to seek damages. The third type of term is the concept of an innominate term, and in some ways this is an odd one, in that it is a definition born out of a seeming difficulty on the part of a court trying to determine whether a term was a condition or a warranty. The leading authority on innominate terms is the case of Hong Kong Fur and Kawasaki, in which the relevant term provided that a ship was to be in every way fitted for ordinary cargo service. The ship was not fitted in that manner, and it took a number of months for the problems to be rectified, 5 months out of a 2-year lease. The hiring party sought to repudiate the contract for breach, and the lenders, the claimants, sought damages for wrongful repudiation. The Court of Appeal held that the term was simply too complex to be analysed as either a condition or a warranty, and that instead the legal ramifications of the breach of such a term should be determined with reference to the effect of a breach. For a party to be entitled to repudiate under such a term, the effect of a breach would need to be such as to deprive the party not in default of substantially the whole benefit which it was intended that he should obtain from the contract. Since, in this case, the ship was available for roughly 3/4 of the hiring period, the court felt that the breach was insufficient to justify repudiation. And there is a trade-off here. Classifying a term as a condition means that the innocent party has a right to repudiate, no matter how trivial the breach. Whereas if the term were a warranty, even the most damaging breach entitles the claimant only to damages. An innominate term means that the remedy can be linked to the effects, which is a more flexible, some would argue made proportionate approach. But clearly it comes at the cost of certainty, since at the point of signing the contract, the parties will not know what their potential liabilities would be. Harsh though a strict classification as either a condition or a warranty might be, it is, at least, certain. The last point I want to touch on is that of the word indemnity, and although an indemnity is not a type of term in itself, it's often used in that manner incorrectly. The term indemnity describes a basis for calculating damages due, whether they are on a normal basis or whether they are on an indemnity basis. An indemnity is often characterised as like-for-like recovery, such that for every penny the reliant party is out of pocket, they will recover that sum from the other party, truly making good their loss. There is no clear adjudication on whether, in the case of reliance on an indemnity basis for recovery, the claimant is required to mitigate their loss or not. Although you may hear the casual language of breaching an indemnity, my feeling is that this is a rather loose turn of phrase, and it is probably more correct to say that the party has breached a condition or a warranty or an innominate term, to which the parties have agreed that the remedy is recovery on an indemnity basis.